So the test is objective.
Indeed, Chair.
If you read the messages, the WhatsApp messages, if upon objective reading, they don't convey a message of unwanted messages, what then?
Yes, it is indeed so that in the majority of the WhatsApp messages, she did not rebuff him in the words itself. That is the reason why we had to call Ms. Lisa Vetten to explain that. But if we look
Sorry,
at
don't go there now, because you can't call somebody to come and interpret the message of somebody else. Abdux Kakane asked her, are you a trained psychologist to come and read people's minds? She said, no. So don't go there. Don't go there. Let's go to my question.
But if we look at...
Can I just pose that question? If the test is a reasonable man, if you look at some of the messages that she herself wrote, to a reasonable man, they don't convey unwanted response. What then? Because the test is objective. It's not Dr. Vettel's subjective interpretation.
No, it is true. But if we look at her messages, she does not answer him clearly. She tries to avoid the conversation, and she came and explained that. She did not know how to answer him. But if we look at the 20th of June...
Because you're not answering my question. I don't want us to argue. I said to you, what if, objectively reading the messages, they don't convey unwanted participation? What then?
Then we must look at this 20th of June, where she specifically said no, and she even quoted a Bible verse. So there is instances in her messages where she came out to say no.
Where there isn't?
Then the court must decide what is in front of, not the court, the tribunal must decide what is in front.
And by the way, you speak of the 20th, you talk about in East London.
That conversation, yes.
Yes, but the respondent agrees. In that context, there was a rejection because the respondent asked the question, if we meet there at your place, and the danger being that we may melt, shall we end up with being intimate? She said no. And the respondent accepts that there was a rejection with regard to the suggestion of being intimate, but not to flirtation. Let's distinguish that. But anyway, I just wanted to ask you that, because you see, the real question here is whether, upon reading the messages, which we're going to read, the real question will be whether the messages objectively, reading them objectively, what do they convey? That's what's going to happen, isn't it?
That is correct.
And if you find that they were unwanted, well, they were unwanted. If you find that they were wanted, or some of them were a mixture, we shall so find. But we are going to read the messages ourselves.
But that is why it is important to note that even a single incident constitutes sexual harassment. So where she said no and he continued after that, that constitutes sexual harassment.
You said she never initiated.
Initiated sexualized messages.
Yes, thanks. You said so.
Yes.
Is that correct?
She never initiated it.
All right, okay. If we find that she did initiate,
then I am mistaken, but according to my reading of the messages, I could not find that she initiated the sexual conversations. She might have answered to it, but she never initiated it.
You referred extensively to the incident of the 14th.
Yes.
Is it the 14th or the 15th?
That is still not clear.
According is that not part of the problem? That up to now it's not clear?
That is a problem, Chair.
And there's something that I want to ask you about that, because you talked about it quite a lot. I noticed that there is an argument by respondents' attorneys that with regard to the 14th, when the complainant said she left the court in the afternoon at a certain time, they asked you, sorry, you remember the complainant, the respondent asked for and produced, after this allegation came up, a recording of the movements of his vehicles on the 15th, which showed that he left the court around the 15th to some other place. I noticed that the respondent's lawyers say that because the complainant says that she left at a certain time on the 14th. And they say, no, she left earlier than the JP secretary. I noticed that they asked you to produce a record showing the movements of a vehicle. Apparently it's a government vehicle. They say that they asked you to produce a record of the movements of a vehicle on the 14th. Do you recall that?
I recall that.
Why was that not done?
At that stage, it was not known that they are talking about the fact that the complainant left, the leaving of the premises from the complainant and the judge's secretary, that there was a discrepancy. The laptop register was only provided later. It was never in dispute that the complainant was there. It was never in dispute that the judge president was there.
But there's a dispute as to when she left. The dispute is, let's not fudge issues.
Yes?
The dispute is, the respondent says the complainant left before the JP secretary. The complainant had said the judge's secretary had left earlier. But the respondent says, no, the person who left earlier is complainant and not the judge's secretary. And then they produced a record, security register, which shows that the complainant left earlier and the JP secretary later. That is the dispute. And then they said, to confirm the fact that the complainant left earlier, please produce the records of the movement of her vehicle.
No, that was not what was requested. At the stage when it was requested for the tracking record, it was not known that the judge's secretary left after the complainant. That was not known to me at that stage.
Anyway, if I'm wrong about that, they will speak for themselves, because that's what I thought. And, okay. I think those are the clarifications I sought.
Thank you.
Advocate Skipper, just one question for you, please. In the event you are to find that the conversations or the exchange of email of WhatsApp messages between the complainant and the JP were consensual, would that still sustain the charge of sexual harassment then?
No, because then it's not unwelcome. If it's consensual, then the unwelcome part falls away.
Then what about then the element of gross misconduct then?
If there's no sexual harassment, there cannot be gross misconduct.
Okay, thank you. Thank you.
Sorry, there's something you referred to lack of credibility on the part of the respondent in your submission, and you are entitled to do that. Are there no aspects in the complainant's evidence which raise issues of credibility? If there are, you haven't mentioned them.
I think there is definitely aspects of credibility issues on the complainant's testimony. She could not give answers, especially when she was cross-examined on the two different statements that were exactly the same. So there are definitely some credibility issues in the complainant's evidence as well, but we must also look at what the objective facts, the WhatsApp messages that we have in front of us. That is what we have to deal with as well.
Does it not worry you that the complainant, and this came through questions by Advocate Butland, does it not worry you that the complainant sought to cast Ms. Moretwe as sly when she said, Ms. Moretwe said, I left at 9 o'clock because it was getting late. The complainant said no. And we know why she said that, because she was insisting about the fact that she didn't have a copy of the other statement. The complainant says no. Ms. Moretwe didn't leave at 9 o'clock. She left at 12 o'clock, midnight. She left after 12 o'clock midnight. It's a concerning aspect, because when Ms. Moretwe says she left at 9 o'clock because it was getting late, all of us knowing how dangerous it is in this country for a young woman, and she says, and then somebody says she left after 12 o'clock, which, well, I don't know whether she would have felt safe to leave at 12 o'clock, but it's improbable. Does it not bother you that, with reference to those two statements, does it not bother you that complainant went so far as to cast Ms. Moretwe as lying when she says she left at 9, and conveniently, seemingly pushes her stay to 12 o'clock to accommodate the previous lie? Does it not bother you?
It is not good for the compliance case, yes.